Good morning, good afternoon, good evening, depending on where you're from, where you're sitting right now. My name is Diana Joseph. I'm the CEO of the Corporate Accelerator Forum, and you are here for our Fireside Chat. It's called How to Think About IP, meaning intellectual property. And our speaker is David Smith, who is a counsel with Troutman Pepper. This session is part of our Startup Accelerator. Grace, you can go on to the next slide. So our Startup Accelerator is called CLIck. It's the Startup Accelerator for Corporate Partnership. When you join our Startup Accelerator, you're going to receive a one-on-one session where we're really going to review what you're doing and what you're ready for and provide you with a prescription where you need to be to really interact effectively with startups and what are the first steps you need to take to get there. You'll also be invited to our mastermind sessions where we have high touch, low stakes conversations with corporates so you can develop the network before you get into a higher stakes situation. And we also do mentor focus time where you can observe or receive group coaching from an expert like David or like me even sometimes. So I mentioned I'm with the Corporate Accelerator Forum. The last 5 years, we've been working with corporates who do their innovation by partnering with startups. And in the course of that work, we've really learned a lot about how those corporates function, what they need, why they do it, what their challenges are. And that information can be really, really valuable to startups. That's why we started CLIck, our Startup Accelerator. My partners in this endeavor are Margarita Kiwis from the Peace Innovation Institute in The Hague, Peace Innovation Lab at Stanford, and Corentin Cremé from Orca. They are my fellow program leaders, and they are helping to craft this experience. They're here working behind the scenes. And also here is Grace Oliver, who is my colleague with the Corporate Accelerator Forum. If this goes beautifully smoothly, it's all because of them, and if it doesn't, it has something to do with me. So let's go ahead and welcome David. Next slide, please. I forgot to mention, you can find the information about the accelerator at corporateacceleratorforum.com/click, but you might like to wait to the end of this session to sign up because we have a very friendly discount code at the end, thanks to our partners at Idea to IPO who are helping us spread the word about this work. Next. Our session is called How to Think About IP. And I mentioned the mastermind session and the group coaching session, those are happening right after this event. So if you are here listening live and you subscribe, or you've already been invited, or you're already a subscriber, those are happening today. So that's all entirely possible today. All right, how to think about IP. Next slide, please. This is the first in our series of expert sessions. The next one is on contracts. That's coming in April. After that, we'll have one on design. We'll have one on markets, lots of other important expert topics for topics for startups who are partnering with corporates. And in between those sessions, we're going to do deep dives with startups who are on the journey so you can hear how they've done it, what their challenges have been, and the lessons that they've learned. And also from corporates who are partnering with startups so that you can hear what their opportunities are that they're laying out before you, and what challenges they face, how to partner with them effectively, and what gets in the way. Again, that's corporateacceleratorforum.com/click. Next slide, please. David Smith is a leading authority on the legal issues surrounding the therapeutic use of human tissue and cells. And he's also a veteran biotech industry executive. He counsels life sciences companies on key commercial, intellectual property, and regulatory matters. David, would you give us a sentence or two about how you became this amazing person?
Well, it's all due to my parents, of course, but Diana, thank you very much for inviting me to participate in this. I really appreciate the opportunity to talk about a really important topic for startup companies. I've been working with early stage companies for the last 30 years. I'm based here in Pittsburgh, Pennsylvania. We've had kind of an explosion of life sciences and IT companies kind of over that period. And so it's been a really kind of engaging experience to be working with them at a very early stage, most of them coming out of university, some kind of growing up outside of universities. And so my time has been basically serving as like an outside general counsel for for these companies, which actually included being a co-founder and a member of a management team of a bioinformatics company. So I've had both the sort of the inside and outside experience of working with companies that are in the technology space, generally probably a little heavier in the life sciences, but a lot of the issues that we confront in developing early stage companies and their technologies really are generic to any company that's in the technology area.
Excellent, excellent. And we were, next slide, please. We do get questions from time to time when we're talking to a specialist, how is that going to apply? And you mentioned that you mentioned that you have worked in general tech. And then Grace, you can go on to the next slide, actually.
So I can provide a little bit of background on this. So
great.
I would say universally, the companies that I've worked with, and certainly the company that I was a part of, spend a significant portion of their lives raising money. It wasn't the only thing they did, although sometimes it seemed like it was, but they were raising money for kind of two reasons, really. One was to actually kind of develop the intellectual property that was the core of their companies. And then to build out the teams that had the capacity to really carry that intellectual property into a marketplace somewhere. And what I've learned from working with those companies and certainly listening to a lot of venture presentations by these companies is what really resonates with prospective investors is, as I said there, how good is the story? And that really kind of falls into three buckets. The last two are which are the really critical ones. And the area of risk is where consideration of IP really comes into play.
Right. And that's going to apply regardless of whether you're doing something really fancy with human tissue or whether you have something that's more like a consumer product.
Yeah, if what you're trying to do is differentiate yourself, not just in terms of intention, but also kind of in terms of assets. Intellectual property is really where early stage companies are going to be focused. You know, they aren't bricks and mortar. They don't typically kind of buy a lot of equipment, perhaps. But they definitely have some kind of result of intellectual activity that is the thing that they are going to commercialize. And we'll talk about the different forms of things that can be patented, for example, but that's not the only form of intellectual property. But at the end of the day, what investors are concerned about with an early stage company is how can you tell me, kind of a CEO, that you have an ability to prevent others from doing the same thing you are doing if it turns out that what you are trying to do is really what people want you to do and will pay to have you do it for them. And that's where the risk comes in. Now, what's true is that you're not going to have the full answer at the early stage. It's going to take time for that to mature, but that's certainly going to be something you're going to need to be able to kind of respond to when investors ask you about that.
Indeed. Folks, this is pretty sophisticated stuff. If you have questions of any kind, whether about what he's speaking about specifically or anything else that comes up around intellectual property, please put them in the chat. And specifically, you'll see that our co-host Corentin has named himself Corentin. Put your questions here. Send me your questions, I think is what it says. So please go ahead and type your questions there. He'll be collecting those and we'll be raising them at the end when we do Q&A. Okay, next slide, please. These are things that you and I talked about a little bit before. You're looking at whether if someone else has the strongest position,
right,
you need to be prepared for that. And then there's the challenge of maybe what you're doing doesn't even matter.
Right. So, I mean, that's why we're going to be talking obviously about intellectual property, the forms of intellectual property and so on. My point in kind of bringing this up at this point is to really make sure that we've created a context around that discussion, that there isn't a reward simply for having a patent or a trademark or some other form of protectable intellectual property. It's really the utility of that, and obviously in the startup company environment, it's the commercial utility of it. So if it's important that in thinking about what it is you're trying to do, that you never lose sight of the fact that at the end of the day, somebody has to care about it besides yourself. And so you have to deal with the risks. and not because you have resolved them, but because you've identified them. You're able to convey to investors that you have thought through them and you have a strategy for addressing them, which may still take time to fully mature, as I said. But you also thought about what your ultimate market is for the particular product, because at some point that market has got to be able to sustain the operations of the company. And if it can't, then it really raises the question as to why are you doing this in the first place?
Indeed, indeed. Okay, next slide, please. I just want to highlight a couple of things about why David's expertise. Highlight a couple things from this conversation. One is the IP fundamentals are the same across industries. So the work that David's going to be talking about today, grounded as it is in bio and in the specific companies David has been in, are going to be relevant across industries. And you do want to make sure that what you're doing matters. You want to validate it in some way before you spend too much time, money, energy on protecting something that might not ever matter. Next slide, please. Okay, this sounds like a really basic question. I do think about intellectual property and IP, but I don't know that I really get exactly what it is. I have ideas a lot, every shower and every sleep, I have an idea. I'm not patenting all of those, am I? When is an idea IP?
Well, it probably suggests that maybe somebody should invent a shower whiteboard so to capture these things. But fundamentally, an idea is not in and of itself intellectual property. It's the ability to make of that idea, if you will. So kind of a standard explanation is, I could have the idea of interplanetary travel, but unless I figured out how to actually escape the gravitational pull of the Earth, that's only going to remain an idea. So what ends up being kind of patented, if you will, what the intellectual property really is the ability to do the thing which you've identified as being worth doing or worth creating. And so there has to be a connection there. And that kind of circles back to the idea that there has to be value in what it is you're doing. If no one has the same idea, then inventing something that enables that idea may be useful to you, but not necessarily useful to anybody else.
Right. Next slide, please. So it has to be something that's created, has to be enabled. And next slide. This is your interplanetary point, right? You have to have articulated the thing. You don't actually have to have gotten all the way to the moon yet.
Right, and that's an important point. It's not that, you don't have to be the person who's come back. You don't have to. I'll date myself here. It's not. You could get a patent for getting to the moon. It doesn't mean that only Neil Armstrong or Buzz Aldrin could have been the ones to have filed that application. So you don't have to have fully achieved what it is you are, what it is you're claiming, but you have to be able to establish that how you are going to do that, or what it is you have created, is actually creatable. And so, because otherwise there's no way for a patent examiner to be able to really evaluate whether you actually are in, as the phrase goes, in possession of that invention. That doesn't mean physical possession, but actual intellectual possession of it.
Creatable. I don't know if I've heard that word before, but it's a really key one here. All right, next slide, please. I hear from startups that they're very concerned about big companies stealing their IP, and there definitely are some rough stories out there. So when is that a real concern?
Well, actually, the idea of somebody taking your intellectual property should always be a concern, in the sense that you need to take the steps to protect what it is you've created, and there are a lot of ways to do it. And so, we'll certainly talk about the ways in which you can kind of publicly do that. The most obvious being filing a patent application. But there are other things you can do. Obviously, the best way to protect a secret is to not tell anybody. There is a whole category of intellectual property known as trade secrets. Now, obviously, some people need to know what that secret is in order to be able to act on it, unless you're doing everything yourself. And that's where you do things that,
Right.
you enter into non-disclosure agreements with, people that you are working with as consultants. You certainly do that when you are talking with outside companies you may be looking to partner with. You create, kind of a set of legal obligations that you use to preserve your intellectual property to minimize the chance that someone will take it. And if someone does, to have recourse if in fact they do.
Got it. You're engaging the legal system to help you make those protections work. Okay, next slide, please. Again, if you didn't enable it, then it's not IP, and you want to be the first to file. This is something that you told me. Do you want to say another word about
Yeah,
that?
I mean, every country has its own patent law,
Mhm.
and people will typically file applications in multiple countries, not in every country, because the cost of that is astronomical. But you think about where it is that people are likely to have interest in using what it is you've invented. So not surprisingly, a lot of people file in the United States. Lots of people file in Europe. Lots of people file in Asia, South America. I mean, any places where you think that they are going to be potential customers within reason, right? I mean, because again, the cost for everywhere is really high.
Mhm.
But you also have to keep in mind that every kind of jurisdiction has its own rules. It used to be for a long time that the United States was different from the rest of the world in that the United States would award the inventor who was the first to actually create the invention. Which is
Ah,
why people kept lab notebooks, and other ways of recording when they had actually come up with an invention. And that's still very important, but it doesn't have quite the same kind of significance that it once had, where you could use the lab notebooks and the other evidence you had of having invented something before somebody else to defeat a patent that was filed by somebody who had invented his or her invention after yours.
mhm.
Uh, the rest of the world wasn't really didn't operate that way. They had what was called a first to file statute, which meant that the person who got to the patent office with the application would be the first would be rewarded the patent application, and somebody who came afterwards, even though that person had invented before the first filer, could potentially be out of luck. Now, there are exceptions to that. If it turns out that the first filer actually stole your invention,
That's
that's
not
not the way it works. It's not the Wild
right.
West.
Right.
But it does mean that it's important to kind of be about the business of identifying what it is you invented. I mean, to really understand it, and then to begin the process of actually figuring out how to protect it, especially if you're looking at filing a patent application around
So,
that invention.
so that filing date is crucial. Folks, if you have questions, we are going to be doing Q&A at the end. Go ahead and type them into the chat, especially directed to Corentin, who's one of our other program leaders. I believe his name shows up as Corentin. Send me your questions. So that's how you know he's the right person. Next slide, please. Okay, and I loved how you put this to me when we were talking about it earlier. So, this conversation really came about because I work with corporates a lot, and I don't see them as sort of like looking to claw away an idea from a startup. They have other ways to get ideas. That's not a primary function. But to your point about trade secrets, if a startup says something about their secret, the corporate or really anyone else can't unhear that. So the startup is influencing the corporate, and if you leave the idea sitting out there, someone is going to pick it up.
Yeah, and this also becomes important in making public presentations. You've invented something and you're invited to go to a conference, and it's the thing you're most excited about perhaps, and you give a presentation on your latest invention. You've done nothing else to try to protect it beforehand. Anybody in the audience is free to hear that,
Mm-hmm.
and is free to use that information any way they see fit, because it's provided without any conditions whatsoever.
Mm-hmm.
So those are the things you just need to be kind of conscious of.
Mm-hmm.
And just to make one final point about the kind of the big company issue. I mean, it is certainly true that large companies have significantly greater resources than small companies when it comes to battling over who owns what. But that they aren't just using their resources for that. They obviously have significant research and development teams who could very likely be working in the same area that the startup company
Mm-hmm.
would be, and that just means that it's important not to kind of sit on your hands when you have identified something which is of a patentable nature. And the way to determine that, obviously, and this is not intended to be as a particular plug, but it's just a reality that if you're going to do something like that, having a dialogue with, a patent counsel that you're comfortable with, you trust, and who seems to be familiar with the area of intellectual property you're focused in or technology you're focused in,
Okay.
it's important to begin to frame what that invention really is from a patenting perspective. And we'll talk more about that as we go along.
Yeah, let's get some more into the meat of it. Go ahead, Grace. Next slide, please. We've noticed that when the startup walks in with real confidence in their IP strategy, that's a signal of maturity and everyone feels more comfortable. So if you come in nervous and clutchy, that makes your potential corporate partner nervous too. If you come in with like, this is what we're protecting, this is what we're willing to share, and you're real clear about it, everyone's more comfortable. You pointed out to me, David, and I wanted to share this with folks, the question of whether your IP strategy is actually going to work is a different question from your confidence. You won't really know if it works until it gets tested.
That's right. I mean, I'll put this confidence in the category of knowledge about the risks and opportunities that you have embraced, and a kind of awareness and thoughtfulness about how you approach particularly the challenges and the risks associated with that. So that doesn't mean that you have done it all.
Right.
Far from it. And that's obviously a reality in this space. It can take, depending upon the art section that you're filed in, it could take years to get a patent actually issued. It's particularly long in life sciences. It's far less long in other areas, but nevertheless, it's not something that's going to happen overnight by any means. And so, what typically happens is that, any investor presentation I've ever heard, and the CEO invariably will point out, the strong IP portfolio that the company has. That may be true, but it's not likely to be actually proven at the time the CEO is saying it, because in all likelihood, and frankly, from the CEO's perspective, happily, none of that has actually been tested in court. No one's come to challenge whether or not the patents that you had obtained from the patent office had been validly issued.
And that's why crafting it well and getting that application out is important. Next slide, please. So I asked you, and we'll go to the next slide so we can establish it. What's the first question that startups should consider when it comes to IP? And you told me that it's most important that the first question they should consider is what is important to protect, and you use this bridge metaphor.
Yeah, so the point of that is to point out that the thing you're going to be most focused on is going to be the thing that is absolutely essential to whatever it is you are doing or making. It could be, obviously, if you're talking about a drug, it's the chemical entity, it's the thing that is actually the drug. But there are lots of other things where there are certainly method patents, there are articles of manufacture, there are other things where there are a combination of either elements or steps that actually comprise the invention. And so in looking at what it is you actually patent, you look for the thing that is going to be the most difficult for somebody else. It's going to be the most important thing for somebody else to be able to do in order to be able to achieve the same outcome that you are proposing to achieve through the use of your invention. The bridge analogy is that there can be multiple ways to kind of move around, a geography, but at some point you may be encountering a river, and you're going to need a bridge to get across the river. So no matter how you traversed that landscape, at some point you're going to come to one end of that bridge or the other, and you're going to need to cross it. And so the bridge is kind of a way of kind of illustrating the point that you focus on that kind of critical element of your overall kind of invention. And to be honest, the reason why, the bridge analogy gets used a lot, and as a consequence, people who simply go out and buy patents in order to be able to enforce them against somebody else are often known as trolls. Back to your,
that's why, that's where I never knew. I've heard of patent trolls, I've experienced patent trolls, but I did not know where that word came from. That's the troll under the bridge. Okay, so you want to build a bridge. You're not a troll, but you're the builder of the bridge, and then it's your bridge.
That's right.
And other people have a more difficult way to, other people will have to find a more difficult way to solve the problem. Okay, next slide, please. In a world with lots of rivers, you want to own the most important bridge. Okay, next slide, please. Okay, so here's the thing though. So we were talked about protection a lot. Is there anything that I should share, and how would I be able to keep that safe?
Yeah.
And Grace, I think you can just go ahead to the next slide.
Yeah, I mean, you said you have to share, right? Not just because that's, the age we're living in, but you can't develop a partnership without, with another company if you're not prepared to disclose something about what you're doing. It's the analogy I use is you're not going to have too many dates if your response to tell me about you is I can't tell you. So, but as I mentioned before, you obviously precede that discussion and that disclosure with a non-disclosure agreement. Something which says, I'm going to tell this to you, but it is still my confidential information, and you're not allowed to use it in any way other than to engage in a conversation with me about how we could work together.
Great.
And so that's what you do.
Great. Next slide, please. We're sorry that it's not moving smoothly. Sorry about that. One more down. There we go. Okay, so what we're doing is we're creating legal and mental boundaries, what you're going to keep private, what you're going to disclose, how you want to collaborate using those NDAs, and how you want to really remain separate and say, no, this is my bridge. Okay, next. Options for protecting IP. Next slide, please.
So there's a tendency to think about patents kind of exclusively and thinking about protecting intellectual property, but it's only one of many ways of protecting intellectual property. And here are the kind of the four common ones: trademarks, copyrights, trade secrets, and then patents, of course. And so each one has its own kind of purpose in this. The three that, the trademarks, the copyrights, and the patents, you're all seeking some level of government recognition of your exclusive ownership of whatever is the subject, the mark, the kind of work of art, or the invention in the case of the patent. But trade secrets are a really critical piece of this. It's the part that you don't tell anybody except those who absolutely need to know, and you only tell those people who need to know after they have obligated themselves to maintain that in confidence. Right.
Next slide, please. So we have some notes here for you for next time. So trade secrets, you're just not going to tell. It's really important not to tell them because NDAs usually have a time limit. So if you really want to keep it secret if you can. There can be other confidential information that you do share. Patents, you're going to disclose and you're going to have to defend them. Everyone is going to know what you invented when you put it under a patent. So it's important to make that distinction. And we have a couple little notes here for you also about trademarks and copyrights. We're not going to deep dive on those today. But you do feel free to ask questions about them if that's important to you. We have a link to an article from the Harvard Business Review about how to decide between patents and trade secrets. Next. What is actually patentable? And you can actually go on, Grace.
So this is from a U.S. Supreme Court case about almost 42 years ago. This phrase, anything under the sun manipulated by the hands of man, as the definition of what is patentable. Now, the point is that it's a pretty broad range of things that can be patented. It's not the case that everything can be patented, and we'll talk about it, but it's important to understand that lots can be patented. One of the things I run into a lot in working with inventors is they know typically the most about what it is that is the subject of their inventions, and to them it doesn't seem as big a deal as it might be to me, certainly, and others, just because I don't have that familiarity with that space. And one of the things that I find with companies is making sure that the people who are kind of essential to the development of their intellectual property don't allow their unwillingness to be impressed by their own accomplishments interfere with their ability to actually kind of file patent applications.
Right. Related to that, I often talk to academic founders, and they're used to writing papers. And so making that switch to understanding that this is valuable is an important cultural mind shift. Next slide, please.
So these are the kind of the standard litany of things that are patentable, and obviously it's a pretty broad range. You know, there are a lot of method patents, and probably I don't know if there's a percentage on it, but significant number of patents are method patents, which is a means of doing something, as opposed to a thing that is created. You know, an article of manufacture, or a composition of matter. You know, those are those are kind of easy to imagine. If you've come up with you know, you figured out a new combination of chemicals that's never been seen before. I mean, that's a very distinctive thing, and it's a very identifiable thing. Some of these are not quite as obvious, if you will, in terms of kind of being inventive, but nevertheless, they certainly can be the subject of patents, and can turn out to be kind of some significant commercial value if, you know, kind of, you know, developed in the right way.
Got it. Next slide, please.
So it's not the case that everything is patentable, as I mentioned earlier. There is, as I mentioned at the beginning, there is every state every country has its own patent law. The United States has a patent act. It's actually the ability to have patents is something which is written into the Constitution. But it's that ability to have a patent is really kind of enabled, if you will, through the patent statute, and it identifies things that are simply not patentable, as well as case law, which actually kind of builds upon that. Laws of nature, you know, human beings, abstract ideas, and then things which are just kind of against, you know, public policy. You know, we're not creating patents for nuclear weapons, for example.
Right.
So.
Okay, next. And so once you've found something that is patentable, how does that actually get evaluated? And Grace, you can go on to the next slide.
So there are kind of three requirements for something to be patentable, assuming it is patentable subject matter. It has to be useful, novel, and non-obvious. And I'll go through each one of those. And the section references are to the kind of key elements in the Patent Act where these are described. It has to be useful. In other words, there has to be something that can be accomplished with this invention. It's not just an ad. You know, a publication, for example, may be in addition to kind of the, you know, general knowledge of us all, and that's good. But it doesn't. It's not useful in a kind of an immediate sense. It doesn't. You know, you can't use that to be able to accomplish something else. If you create a machine, the machine can do something. If you create a composition of matter, that matter can be used for something. Obviously, if you have a method, that method kind of leads to an outcome, and that outcome is kind of useful by virtue of being an outcome in some respects. It's not a high bar. I mean, you know, utility, as described in the literature, is not the thing that people tend to focus on, but it still matters, and so shouldn't be overlooked. The real focus is on the question of novelty and non-obviousness. You know, the reality is that everything that has been invented comes after everything else that had been invented previously. So, you know, it's maybe at the year zero, it was a lot easier to get a patent because nothing had been invented. But you know, here we are, you know, several thousand years later, a little bit more difficult, but not certainly by any means impossible. There are several 100,000 patent applications filed every year just in the United States. But it has to be new. It also has to be something which has not been publicly disclosed. And I mentioned that a little bit earlier. So it can be novel in the sense that no one else knows about it, or at least no one else who's an ability to use it, you know, kind of without kind of legal obligation. So, you know, if you use your invention to make something which you've now been putting on the market and been selling, if that happened, that started a year before you filed your application, you will not get your application issued. It's been time barred. You will also not be able to file that application outside of the United States, because the United States still has a 1 year kind of grace period, if you will, but not every, and in fact, most countries do not. And so it really is important to kind of to be proactive about getting an application filed in order to be able to protect your ability to ultimately have a patent be issued on your invention. And then not obvious means that it's, as I said before, you know, every invention kind of comes after every other previous invention. And the challenge is to be able to explain to the patent examiner that the invention you've come up with is not the next kind of logical iteration of whatever had been invented before. It has to be something which is, maybe a combination of prior inventions, or, a combination of various other kind of methods or elements that no one had really had a reason to think about before. It could be because they didn't think it would actually produce anything useful, or that it wasn't going to be possible because it was just not, there wasn't a way in which you could actually manipulate those, those ingredients to combine into something which could be useful. But those two issues of non-obviousness and novelty are really at the core of identifying what is a patentable invention.
Excellent. Next one, please. I think we've talked about this already. It's a product of human ingenuity, something that you've actually enabled. Okay, next. When's it not valid? Go ahead. Next slide, please.
So obviously the process of patent examination is for the examiner in the U.S. Patent Office, and I'll just use that as an example, but it repeats itself around the world. Is instructed by law to grant a patent if it meets the elements required of it under the statute. The statute actually speaks in those terms, that a patent shall be issued if these things are found. But it also means that the examiner is also supposed to be giving attention to things that may mean that the patent should not be issued because it doesn't meet those conditions, whatever they may be. We mentioned about non-patentable subject matter. Inequitable conduct, briefly, is just where you're not telling the truth to the patent office when you should be telling them. You're misrepresenting the nature of your invention, or you are in other ways not being candid with the patent office about the nature of your invention and the background of it. It may be that what you added in the patent examination, or excuse me, the patent specification, and we'll talk about this in a second, doesn't align with what it is you've claimed. In other words, you haven't enabled it. There's no evidence to show that you actually have an invention, at least not the invention you're trying to claim. But what the patent examiner generally tends to really focus on is this question of prior art. And this goes back to those elements of novelty and non-obviousness that I was talking about before. This is really where most of the discussion centers around between the patent attorney and the examiner over whether or not the application can ultimately result in an issued patent.
Got it. All right, next slide, please.
So a prior art search is a kind of a, you don't have to do it, but it really helps in terms of drafting a patent application that's more likely to actually result in an issued patent than not. And basically what this is it's a search of broadly speaking, the literature that would describe comparable inventions. And first of all, obviously it's previously issued patents, and nowadays there are millions of them. So that's one source, because every patent discloses an invention and it needs to disclose it comprehensively. So it's a really important research resource for patent examiners, but also for people who are drafting applications. But then also scientific literature. And depending upon the area of technology you're in, that may be more or less robust. Obviously, if you're in life sciences, an academic discipline that's going to have a journal or multiple journals, there's going to be a rich resource of that kind of prior art as well. And so what a lot of people will do is they'll commission companies that are specifically created for the purpose of creating a prior art or conducting a prior art search to begin to figure out whether or not there is prior art that is potentially problematic when it comes to establishing the novelty or non-obviousness of your invention.
The next slide, please. I've got some notes for you there. You've also suggested getting help from a firm to take you through that. David's given us a link here to where you can dive right in with the U.S. Patent Office to look at what patents are already out there. And then, of course, you need to look in the literature as well, just like the examiner would. Next slide, please. I'm going to go quickly past this. We have the notes for folks, but we want to go on to the next topic. One more, please. Let's look at the elements of a patent application, then we'll start to wind down so that we can have some Q&A. Go ahead.
Great. So these are the three kind of critical elements of the actual application. It really begins with the written description. This is the thing that actually lays out what it is you've invented. And there are lots of permutations to that. A lot of times you will use it as a way of demonstrating non-obviousness. I mean, there are kind of tricks about how you can kind of present that in a written specification in order to convey to the examiner, sort of how not miraculous necessary, but how unexpected it is that this invention kind of came into focus.
Mm-hmm.
You have to show that you actually have possession of the invention, as I mentioned before. That's the enablement part. That this is something which, as I said, you haven't necessarily, it's not that you've done it, but at least you have developed that idea to the point where it is doable in kind of, in our day and age. It's not dependent upon the invention of the ability to travel faster than light speed, for example. And then you need to identify kind of what is the best way to use the application. That kind of ties in a little bit to enablement, but it's also part of the articulation of the invention that goes into the public domain. And keep in mind that what the patent really does is if it's issued, it enables you to prevent other people from doing the same thing. It's not a license from the government that enables you to do it. It's what enables you to prevent somebody else from doing it. But at some point, somebody else is going to be able to do that. And strictly speaking, that somebody else ought to be able to do it from the moment they have read your patent application from start to finish. It doesn't mean they can do it, but it means that the application of itself contains enough that would enable, as they say in the phrase, someone skilled in the art to be able to reproduce that invention.
That's what you were talking about with that interplanetary travel thing. Someone should be able to read your method for getting to the other planet and know how to do it. That's what enablement means. Okay, got it.
Right.
Okay, let's go on to the next slide. This is a question that's of great interest to me, but I think there are other questions that might be of greater interest to folks in the audience. So I will just let folks know that this is here. How should I write it broad and how specific? You go ahead and click to the next slide. We'll just flash by it. There's this lovely chair analogy. Go ahead. If a cave dweller patented four-legged object that people sit on, okay, because nobody ever had that before, then if someone made a three-legged object people sit on, that would not infringe on the patent. On the other hand, if you tried to patent any human-made thing you sit on, the examiner might consider that too aggressive if there have already been people sitting on human-made things at that point.
Yeah, so it's really a balance between breadth and specificity.
Right.
You want to try to be as broad as you can be, but the reality is that there are going to be prior inventions that are going to limit that. You just have to make sure you understand what is really the nature of your invention and don't get too hung up on its specific attributes as you've created it. And that's where the working with the patent attorney comes into focus.
Right, and the prior art. It's not so much the specific attributes that you've created as the specific attributes that have already been pushed out by other patents. Okay, next slide, please. If you have one final message for startups before we go to Q&A. Go ahead, next slide, so we can remind them what it was.
Right.
Yeah. So there we go. Don't
Yep.
assume you have to have all the answers at the start. Thank you so much, David. This has been really interesting. We want to open it up to Q&A now. Just very briefly, next slide, please. Oh, pardon, we still need the share there. So I want to let you know that this is part of our Startup Accelerator. Thank you, David. And next slide. This is part of our Startup Accelerator, which is called CLIck, the Startup Accelerator for Corporate Partnership. Our next session is with a corporate leader in the luxury travel industry who's going to talk about how startups can help corporates get on trend and be on trend, and how that's an opportunity for startups to reach the corporate. And then we'll have Jonathan Tan, who is the founder and CEO of a battery capacity company that's getting real deals with startups, and can talk about what that looks like and what he had to do to get there. Next slide, please. We do these events on the second and fourth Tuesdays of each month. The fireside chats are free. The mastermind and mentor focus time are part of the paid accelerator. You pay us and you are our customer and we take care of you. And that's $190 a month, but we have a discount for you for the first month. It's 40%. We're not going to commonly provide discounts like that, and that will be active until September 1st. After that, there may still be a discount with that code, but it probably will not be that amount. So recommend you do it soon. The discount code is IPO, thanks to our promotion partner. And if you do it today, we will know that, and you'll be able to participate in our mentor focus and mastermind session. Next, it's time for Q&A. So actually, why don't you leave that slide up, Grace, the one with the link in case people need that. And Corentin and Margarita, I want to invite you to unmute and come on camera and bring the questions that you've heard from folks, yeah, go for it. Go ahead, Corentin.
Yeah, so lots of questions actually in the chat.
Excellent.
Let's see. Let's pick one. One question was, what kind of time and budget should startup allocate for patents and IP protection?
So the time kind of is a function of the subject matter of the application. It takes the understand that at least in the United States, and probably true everywhere, the patent office, the examiners of the patent office are assigned to different, what are they called, art groups. So there's, and there are lots and lots of them. Some can take a really long time to work through applications. And so it could be, 3-4+ years, depending upon, the art you're in and the complexity of the invention and the degree to which there is prior art that the examiner and the attorney for the inventor or the assignee of the application need to kind of sift through. Others can go through, maybe in 18 months. Cost, again, it kind of varies with the complexity of it. I think that, a decent application in a not super complex area shouldn't cost more than $5,000 to $10,000. That includes the process of interaction with the patent office. The way it works is you file your application, and then at some point you will get what's known as a substantive office action, which will be a written communication from the patent examiner describing any deficiencies that are found in the application, identifying which of the claims are allowable as presented, which are not. And then there is a back and forth that could be a couple of times before there's an agreement on what is actually allowable as a patent and what the final language of the claims will be. So it is an iterative process, but and depending on how contentious it can be, that could get to be fairly expensive. But you're correlating that with potentially the market value of that invention.
That's right. So there's enormous value there. And just to build on that, when you say 18 months to 4 years, you're not talking about how much time the startup is spending. That's just how long it is from the application until the completion of the patent, until the approval of the patent.
That's right. So, if you're really pushed, what does happen, and frankly should not happen this way. We'll be advised that a professor so-and-so at a university is going to be giving a presentation on the professor's invention next week, and nothing has been done about filing an application and that kind of stuff. At an absolute minimum, you could take whatever presentation that person is about to deliver, put the appropriate cover pages on it and send it down to the patent office as a provisional patent application, as a means of just kind of creating some ability to then go forward after the professor's presentation and develop a more comprehensive actual prosecutable utility application that will have the benefit of having been filed earlier through the provisional.
Right.
But ideally, you don't do it that way. You do actually spend time in developing the language of that application, because it's really, once you've filed a patent application, the one that is actually going to be examined, you cannot change the language of that application. It is, you could send it down to them on stone tablets. It is what it is. And if it isn't in that application when it's filed, it's not getting in afterwards. The one part that can change is the claims, and those can change a lot over the course of the prosecution.
Got it. That's really important to know. So like, can you give like a rough idea of like the percentage of time that a founder would need to put into working on a patent, or like over that 18 months, let's say for a fast one, are they working 10% of their time on that, or like a big push at the beginning and a big push in the middle?
Yeah, I mean, the 18 months is actually the examination process. So
Right.
you've already got your application done. I mean,
Right.
almost all the work from the inventor's perspective is done
At
before the application is filed.
Got it.
Now, when you get that substantive office action that has questions about, this prior art or that prior art, or have you really enabled the invention, whatever the question might be, there's going to be a need to re-engage with the inventor to kind of go through those objections from the examiner and figure out the best way to respond to them. Some of them are going to be legal, many of them are going to be legal. And so the lawyers can handle those, but there are going to be potentially substantive questions that look to prior art, and the inventor will be critical in being able to distinguish the new invention from whatever had been disclosed or invented before.
Great. Let's take one more question, Corentin, and then if you're here live in the room, we're going to stop the recording in 5 minutes, but we have a way for you to ask your questions that we'll explore together after we turn the recording off. So one more question, please, Corentin.
Yeah, there was a question. Is there like differences between biotech and health tech and a software hardware product?
Well, yeah. From a patenting perspective, no. I mean, the same elements have to be true regardless of what the nature of the invention is. The one thing is also important, though, and this is where you, again, this goes back to my initial point about context, is that there are certain industries which are very patent intense. Life sciences generally is of that nature.
Mm-hmm.
Others perhaps less so, partly because things obsolesce faster, in other industries than they do in life sciences. And so, getting a 20-year term to exclude others from practicing an invention maybe not have all that much value. Speed to market may matter more than being able to protect that, that invention in that particular way. So it's, that's part of the nuance that goes into identifying the best ways to protect your intellectual property. And that's where you're working with, you're combining, your understanding of the market and what you know from, looking at competitors, what you've experienced on your own, with a patent attorney who is experienced in your particular area of technology or industry, to really figure out what's the right strategy to be able to best protect the intellectual property of the company and to position that asset of the company in the best light possible, both in order to be able to enable the company to fully exploit it, but then also to create or add to the value of the company for a potential acquirer.
Great. And we
Do you
are.
have time for one last question by any chance?
Can you do a real quick one, Corentin? Because
actually there was a question with the pre-revenue valuation. How do we prepare the pre-revenue valuation for a patent for an investor outreach?
Unfortunately, it's a short question with a really long
answer.
It's not easy. You look at comparables. There are people who can do asset valuations for intellectual property. It's it's going to be a discussion point with somebody else. If you're presenting a value to somebody, they're going to have their own views on it. There's no formula for figuring that out.
Okay, that's a really important question. Actually, we will make note of that. It might be that we should develop a fireside chat around pre-revenue evaluation, although we are really focused on corporate partnership. And so I appreciate the question. We'll delve into how that resonates in the corporate partnership context. David, thank you so much. This has been such an interesting conversation. We are going to stay on camera, but we're actually going to stop the recording now. Thank you, everyone, for being here. We will send you the slides and the recording at a later date. And please consider joining our Startup Accelerator, corporateacceleratorforum.com/click. Take care.